parole revocation hearing? I've been assigned to a parole revocation hearing?
Pro bono work is vital to our court system. One of the most cherished protections citizens have is the constitutional right to be represented by counsel. We as lawyers are privileged to be able to perform that vital role in our system of justice. We also have an obligation to help those in need who cannot afford to retain counsel. That said, when attorneys are assigned a pro bono case in an area outside their expertise, that can present a challenge. For that reason, we've created a manual to help navigate the process. The manual and this video are meant to help you provide competent counsel to your client. We also encourage you to speak with colleagues, friends, and other attorneys who frequently deal with this type of work, and to contact the pro bono coordinator in your vicinage to better understand the process. Pro bono work is not just a critical component of our justice system, it also enables us to gain valuable experience and learn about new substantive areas of the law by representing indigent defendants who are entitled to counsel. In other words, pro bono assistance can foster professional development. At the same time, it allows us to perform a critical public service. We thank you for your service.
The law requires all attorneys licensed in New Jersey to represent indigent defendants without pay where the legislature has made no provision for the public defender to represent those defendants. These are commonly referred to as pro bono assignments. When the Vicinage Pro Bono Coordinator gets a request to assign an attorney for a pro bono case, they check the Madden v. Delran computer list and assign the case to the next eligible attorney. The list is alphabetical by last name. It is filtered by the number of pro bono cases previously assigned. The coordinator has no control over choosing an attorney. Attorneys can be assigned to represent defendants for municipal court appeals, domestic violence contempt, or, in this case, a parole revocation hearing.
Parole revocation hearings are administrative proceedings. They're not criminal proceedings. During the parole revocation hearing, rules of evidence do not apply. Hearsay is admissible, and there is basically no plea bargaining done whatsoever.
The pro bono coordinator creates the pro bono assignment letter, which is issued by the Superior Court assignment judge. The letter assigns counsel to represent an indigent defendant for a parole revocation hearing. Counsel should review the assignment package. The assignment letter provides the defendant's name, location, and case number. The package also contains a primer for assigned counsel. That primer specifically discusses parole revocation hearings and sets forth guidelines on how to proceed with this type of case. Your assignment package contains contact information for the New Jersey State Parole Board Revocation Unit. The Parole Board will send you discovery materials which have also been provided to the parole violator.
Hello, this is Hesham Thomas from the firm of Thomas & Thomas.
Discovery materials will include a notice of probable cause hearing and a list of alleged parole violations, as well as any attendant legal rights. Included on the violation notice will be information on the date of parole, commitment offense and sentence, and end of supervision date, commonly called the max date. You should also find the State Prison and State Bureau of Identification numbers. These are two State Parole Board tracking numbers used to identify all cases under parole supervision. Any correspondence from assigned counsel should include at least one of the two tracking numbers. Your package should also include special parole reports. These are reports submitted by the parole officer, such as arrest reports, missing reports, and disposition reports. It will also contain the date and time of the hearing at which you must appear. The assigned parole officer records significant supervision contacts that resulted in the violations in a chronological supervision report. The parole supervision certificate is issued by the state parole board prior to the defendant being released from the state or county institution. It indicates the sentence information, general condition of parole, and any special conditions. The notice of probable cause hearing refers specifically to the alleged violations of the general or special conditions noted on the parole certificate. Sometimes a parolee is charged with violating parole because he or she has been charged with another unrelated crime. You should reach out to the attorney handling that criminal matter to discuss strategy, including whether or not the parole revocation hearing should occur prior to the court disposition of the new charges. Once you have received discovery, time is of the essence since the hearing is already scheduled. You should take time prior to the hearing to meet with your client and explain the procedure. Counsel should contact the correctional facility where the inmate is housed in order to set up the client interview. The facility can apprise you of the regulations for interview hours, use of recording devices, appropriate dress, and the need for valid identification in order to enter the facility. If your client needs an interpreter, you can make arrangements with the revocation unit. If counsel needs additional time or to reschedule, contact the revocation unit immediately. Counsel should remember their client is being held in custody without bail pending the hearing. Parole revocation hearings may take place via video teleconference or in person. The parole board is flexible as to locations. Assigned counsel can appear either at the parole board headquarters or where their client is in custody or a local district office, whichever is more convenient. If counsel is not in the same location as the client, counsel may ask to briefly confer with the client in private via video outside the presence of the hearing officer. This is not a substitute for a full client interview, which should have already taken place. Prior to taking testimony, the hearing officer will explain the bifurcated structure of the process, the probable cause hearing versus the revocation hearing.
All right, Ms. Brown, the revocation process entitles you to a two separate hearing process. The first hearing is called a preliminary hearing to determine if probable cause exists that you have violated one of the conditions of your parole supervision. If based upon the evidence in the testimony that I hear today, I find that probable cause exists that you have committed one or more of the violations, then you may be held over for a final revocation hearing. That revocation hearing is the second hearing that you're entitled to. The only difference between the revocation hearing and the preliminary hearing is that the Division of Parole has to prove that you committed the violations by a clear and convincing standard, rather than just a mere showing of probable cause. Now, as both hearings are essentially the same, you can elect to have today's hearing as your revocation hearing, meaning that you would not have to appear for a second hearing to be conducted at some point, and you can have that hearing today. If you choose to have your revocation hearing, then the board will review your case based on the record that we have here today, the evidence and the testimony that's being presented, and they will make a final decision based on that information. Do you understand that?
Yes.
And how do you wish to proceed, counsel?
We wish at this time to waive the probable cause hearing, and we wish to proceed with the revocation hearing today.
Thank you. And does the division have any objection to that?
No objection.
Okay.
Although the offender is entitled to two separate hearings, the vast majority of offenders do elect to waive the probable cause hearing and have the matter proceed as a revocation hearing. However, there may be certain circumstances where the offender would like to have two separate hearings.
If you do choose to have only a probable cause hearing, remember it is a limited inquiry. Its purpose is to discover if there is a factual basis warranting detention of the parolee pending the outcome of the parole revocation hearing, and whether there are reasonable grounds to believe that the arrested parolee has committed acts constituting a violation of parole. The state carries the burden of proof. Whether it proceeds as a probable cause or parole revocation hearing, the procedures are the same. If the matter proceeds as a probable cause hearing, the state must demonstrate probable cause. If it proceeds as a revocation hearing, the state must prove the allegations by clear and convincing evidence.
Swear or affirm that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Okay.
After the oath, the hearing officer will recite each alleged violation of parole and ask the parolee for a denial, admission, or an admission with an explanation.
Failed to refrain from the purchase, use, possession, distribution, or administration of any narcotic drug, controlled dangerous substance, or controlled substance analog, as defined in New Jersey Statute 2C 35-2, imitation controlled dangerous substance or imitation controlled dangerous analog, as defined in New Jersey Statute 2C 35-11, or any paraphernalia as defined in New Jersey Statute 2C 36-1, related to such substances, except as prescribed by a physician, as evidenced by your admission for use of marijuana on August 23, 2014.
Counsel, how does your client plead on this?
Pleads guilty with explanation.
Thank you. Okay, Officer Donnelly, continue.
Under special conditions, you failed to successfully complete the Atlantic City CRC Community Resource Program as evidenced by your disciplinary discharge dated August 26, 2014.
Counsel?
Guilty.
If the parolee denies the alleged violation, the hearing officer will ask the parole officer or other relevant witness to testify regarding the facts surrounding any contested violation.
Okay, it's your witness.
Good morning.
Good morning.
Again, we stated your name for the record previously. You've been sworn in. Your name is Sherry Sandler, correct?
Correct.
And who are you employed by?
I'm employed by the Kintuck Group, located in Bridgeton.
And what is your position to Kintuck Group?
I'm a senior case manager.
Thank you. And on the date of incident, October 2nd, I believe, were you working that day?
I was.
And did you happen to come into contact with Ms. Brown?
I did.
Okay. What, if anything, happened?
At that time, Ms. Brown was pulled aside. It was time to randomly drug test all the residents on her unit. I pulled Ms. Brown aside and advised her that it was time for drug testing, and she used profanity and refused to submit to the test.
When the testimony is finished, the parolee or attorney may cross-examine the
And
witness.
when you said that Ms. Brown, I should say, had displayed a negative attitude towards her wife, has she completed any programs?
Okay, she was currently participating in drug treatment. However, she was unable to complete her employment class.
Okay. Have you heard residents from time to time while in the program using profanity while they have been in the program at any time, or?
Absolutely, that occurs. However, it's in violation of the program rules, and residents are given a demerit every time they use profanity.
Okay.
Statement.
If the parolee admits to one or more violations, the hearing officer will allow the parolee a chance to give his or her explanation as to why the violation occurred and to submit evidence of any relevant mitigating factors.
All right, counsel, your client has pleaded guilty on the violations. Do you wish to, does your client wish to provide a statement, or are you going to conduct direct examination of your client?
If I may, I would say conduct a direct examination of my client, please. Thank you. Okay, for the first charge of use of or possession of a controlled dangerous substance, that being marijuana, did you admit to using marijuana while on parole?
I was just around people who were smoking. It wasn't me.
Okay. Okay, so again, even though you signed the admission, it basically was not to where you were testing positive. It was just that you signed the admission, but with the statement that you had been around others.
Yes.
Okay. And on the third count, which is failing to successfully complete the STEPS treatment program at the Kintuck Bridgeton facility, did you make a statement that was insubordinate in reference to that?
I mean, I don't think so. I just told her I didn't want to talk to her right then.
Okay.
I wanted to get in the shower. I didn't want to take the test at that time.
And as I said,
When all testimony has concluded, the hearing officer will ask the attorney for any closing
Okay,
statement.
counsel, I've heard the evidence in the testimony concerning this matter, and at this point, you have the opportunity to present a closing argument on behalf of your client.
Okay. Thank you very much. I would just say that Ms. Brown prior to the STEPS program, basically when she was in the CRC program, that her rehabilitation, it seemed to be going well until there was some type of incident that happened when she became employed in the program, and that basically, because it happened outside, we believe that there's still a chance for positive rehabilitation if parole, would be continued.
The hearing officer will then ask the parole officer for a recommended disposition based on their supervision history with the offender and in conjunction with the current
Brown is
allegations
obviously
of violations of parole.
Supervision for the offenses of unlawful possession of weapons, 3rd degree, and theft by deception, 3rd degree.
After the hearing officer will prepare a written summary. That report will also include a factual determination regarding whether the state met the standard of proof.
And I will also include a recommendation after I review the materials and make a recommendation to the board.
Upon conclusion of the revocation hearing, the hearing officer will prepare a written summary. That report will be sent to the attorney for their review and comment. The attorney, if they would like to make comments, should submit those comments in writing back to the parole board. Upon receipt of those comments, the hearing officer's written summary, along with the attorney's comments, will be presented to a 2-member board panel. The board panel will review the hearing summary and determine whether or not parole revocation is desirable. They can either choose to revoke parole and impose a future eligibility term, or they could choose to not revoke parole and continue the offender on parole. Regardless of what their decision is, they will issue a written notice of decision that does articulate their reasoning behind their decision.
A board panel will review the summary report within 21 days of the hearing and make a final determination. If the panel decides to continue the offender's parole status, it may impose special conditions of parole that will help the offender reintegrate into society. The board can revoke parole and impose a future eligibility term, or may continue the offender's parole status with possible special conditions like community-based programs, substance abuse, or alcohol treatment. Counsel will receive written notice of the decision and will relay that information to the inmate. Appeals may be made to the full board. The notice of decision will include a notice of the appeal procedure. Pro bono counsel will be required to represent the defendant for any administrative appeal. Contact your pro bono coordinator if you have questions about the assignment. Contact the State Parole Board Revocation Unit if you have questions about the hearing. You can find more detail in the printed training materials available on the Judiciary website.